My topic today is voting rights and the Constitution. And this is also, in part, a story about federalism. Now, in the history of the United States, access to the franchise was a struggle. Voting was sometimes seen as a privilege to be earned, and universal suffrage was not the expectation or norm through a large part of our history. As some groups won the right to vote, when property and tax-paying qualifications were dropped, for example, restrictions were sometimes simultaneously or subsequently added for other groups. Only in the past 50 or 55 years can we say that we have achieved something near universal suffrage in the United States. And even so, the story is complicated and the lines of responsibility between the states and the federal government are contested. Each state adopts its own rules and requirements for voting and conducting elections. The Constitution allows this. Now, states further decentralize the process and give election administration responsibilities to counties, cities, and township governments. There are thousands of election rules and practices in the United States, not just 50 state election systems, but one person estimated something like 4,600 different sets of rules were possible, and that's more than the number of counties in the United States. For much of the nation's history, that meant that the following kinds of things varied by state: voter registration rules and deadlines, rules for how candidates get on the ballot, what kind of documents, if any, do you need to produce in order to vote? At certain times in the nation's history, if you were an immigrant, you had to bring sealed naturalization papers to the polling place. Ballot design. Palm Beach County, the famous butterfly ballot that was so confusing in the 2000 election, is a county design. Whether or not you can vote in a primary election. Are you registered as a Democrat or a Republican? In my state, independents cannot vote in primary elections, and I can't vote in a Republican primary if I'm registered as a Democrat, and vice versa. Are parties private organizations so that they can bar African Americans from participating? For a number of years, that was considered to be constitutional. Literacy tests, poll taxes, how voter rolls are maintained, purged, and your recourse, if any, if your name is not on that list. Access to absentee ballots, early voting, whether convicted felons can vote, whether students or graduate students attending college in the state can vote there. How long do you have to have lived in a state in order to vote? Some states in the 19th century, late 19th century, allowed immigrants to vote before they were citizens, and other states barred Native Americans from voting even when they were citizens. So in 1924, any Native American who had not already been declared a citizen was declared a citizen by federal law, but it wasn't until about 1950 that the final state was forced to stop disenfranchising Native Americans. From 1965, when the Voting Rights Act became law, until roughly 2002, 2003, the federal government played a very important role in expanding voting rights, so that we could almost say in the United States we had universal suffrage. The government made sure that states and counties that had actively discriminated against those seeking to vote, African Americans and later Latinos and some language minorities, would not continue to do so, and that changes to voting laws and to voting and electoral districting would not cause retrogression or dilution of minority voting. The Voting Rights Act also barred poll taxes and literacy tests in any federal, state, or local election for 5 years. A 1964 constitutional amendment barred the use of the poll tax or any other tax in order to vote in a federal election. And in Harper versus the Board of Elections in '66, the court declares unconstitutional poll taxes as a condition of voting in state elections. They declared it a violation of the Equal Protection Clause of the 14th Amendment by introducing a voter qualification that invidiously discriminates. Justice Douglas, writing for the court in Harper, said, the Equal Protection Clause is not shackled to the political theory of a particular era. In determining what lines are unconstitutionally discriminatory, we have never been confined to historical notions of equality. Notions of what constitutes equal treatment for purposes of the Equal Protection Clause do change. So the Harper decision, like the Voting Rights Act, treat the right to vote as a fundamental right, a precious right, the court says in Harper. But there's a bigger hurdle, because despite this, there is no federal constitutional right to vote. But in Bush v. Gore, the majority of the court made the following claim. The individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as a means to implement its power to appoint members to the Electoral College. So what states gave, they could take away. If the state of New Hampshire decided that they were going to appoint electors in another manner, they could, and you wouldn't have any right to vote for President or Vice President of the United States. So it was a big surprise to many Americans to hear that, but it is indeed true that the Constitution doesn't guarantee that right. After 2002-2003, there was a political reaction, a tightening of ballot access, probably fueled by close elections and the influx of new voters into the system that tended to favor one party over the other. The Supreme Court upheld the Indiana law adding voter ID, photo voter ID requirement in time for it to go into effect for the 2008 election. And that gives states wide berth to implement laws designed to maintain the integrity of the election process, prevent voter fraud, and promote confidence through elections. Now, most court scholars saw this case as a significant departure from what we thought the court was saying about the fundamentalness of the right to vote. Nonetheless, lots of states after the Crawford versus Marion County decision in 2008 began to implement voter ID rules. So Justice Souter said that the court's capacity to see facts depends on what our experience has opened our eyes to, and that this was a way the principled Constitution decision-making works. But there are a number of approved values in the Constitution. The movement of constitutional change is not simply linear. And so it seems that the way of evaluating these competing constitutional values, such as equal protection and federalism, is shifting, and voting rights under the Constitution stand to be affected.